Instrument of accession, my lord, is dated 27/10/1947. And that is at PDF 9 of Volume 1. My lords, what happened in the thereafter, my lords, in chronological order, I'll be obliged if your lordships kindly have a look at the proclamation issued by the Yuvraj Karan Singh in Volume 3 of the written submissions, the compilation of written submissions of the respondents at PDF page 44, part of the list of dates, my lord, of the learned solicitor. Page 44.
Of volume?
My lord, of Volume 3, the same volume which was being referred to by. Because clause 7 and 8 of the instrument of accession was being relied on to contend for the position that there was a vestige of sovereignty which was retained by the Yuvraj even then, even after signing the instrument of accession, because that is what is articulated in the instrument of accession as such. My lord, on 25/11/1949, the draft constitution was ready. And therefore, my lords, the Yuvraj Karan Singh had the entirety of the constitution, including 370 as it was incorporated in the constitution before. Article 1 and 370, my lord, which is incorporated, which is made as part of the constitution, or which is made as part of the applicability of which was made as part of Article 370. All this was before him. And therefore, my lord, on 25/11/1949, if your lordships have a look at PDF 44, Yuvraj Karan Singh issued a, my lord, I'm reading from the solicitor's list of dates, issued a proclamation for the state of Jammu and Kashmir by which he declared and directed that the Constitution of India shortly to be adopted by the Constituent Assembly of India.
So, Giri, you are at PDF page 54?
No, PDF page 44.
44.
Written submissions, Volume 3. My lord,
Yes,
part of the list of dates that was placed before your lordships by the learned solicitor. My lord, the document is also included, but I thought this is easier, my lord, because your lordships will have to keep referring to it again and again. The said proclamation is both worth quoting in full. Sorry.
Yes, I get it. Yes.
Whereas with the inauguration of the new constitution for the whole of India now being framed by the Constituent Assembly of India, the Government of India Act 1935, which now governs the constitutional relationship between this state and the Dominion of India, will stand repealed. And whereas in the best interests of this state, which is closely linked with the rest of India by a community of interest in the economic, political, and other fields, it is desirable that the constitutional relationship established between the state and the Dominion of India should be continued as between the state and the contemplated Union of India, and the Constitution of India as drafted by the Constituent Assembly of India, which includes duly appointed representatives of this state, provides a suitable basis for doing so. I now hereby declare and direct that the Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, insofar as it is applicable to the state of Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India, and shall be enforced in this state by me, my heirs and successors, in accordance with the tenor of its provisions, that the provisions of the said Constitution shall, as from the date of its commencement, supersede and abrogate all of the constitutional provisions inconsistent therewith which are at present in force in the state. So, my lords, therefore, it was understood that on the enforcement of the Constitution of India, my lord, which took place on 26/1/1950, there is no residuary sovereignty that is retained, my lord, by the Yuvraj in the state of Jammu and Kashmir. My lord, the territories comprised within the state are therefore mentioned in the Constitution. It is treated as a Part B state. The provisions of the Constitution are made applicable to the Union of India, including the state of Jammu and Kashmir, with effect from the date of enforcement, that is, my lord, on 26/1/1950. when the constitution commences. It is, my lord, difficult to countenance an argument, my lord, this I say so with greatest respect, that there was any sovereignty which, whether you call it as residuary, internal, as distinguished from external sovereignty, which survives, my lords, the enforcement of the Constitution of India with effect from 26/1/1950, when, after, my lord, the Yuvraj had also made it clear and had declared that the relationship between the state and the union will now be governed by the provisions of the Indian Constitution, which means that we don't have anything more. We are governed by the Constitution of India. We have also looked into it. There were 4 representatives from the state of Jammu and Kashmir earlier in the Constituent Assembly. We have gone through each clause, and we have ultimately looked at 370 also, which is an integral part of the Constitution, which is also a part of the Constitution. And we have therefore decided that we will abide by this. Now, my lords, the question of if this is the integration, therefore becomes complete, my lord, on enforcement of the Constitution, there is nothing residuary about. Now, if your lordships kindly have a look at, my lord, I am sorry, but then to make my submission, my lord, on the question of, my lord, what therefore survives under 3, what therefore survives, my lord, will also have to be looked into in Article 370 and 373, and there is nothing more, my lord, which can be read into it. There is nothing in the Constitution of India, my lord, which carves out an exception in the case of state of Jammu and Kashmir, both as regards the sovereignty, any sovereignty, other than, my lord, Article 370 itself. And 370, in my respectful submission, does not indicate that there is any residuary sovereignty that is left with the state of Jammu and Kashmir. It becomes a part of the Union of India. My lord, the enforcement of Article 370 also, and powers exercised by the President from time to time in issuing a constitutional order, is also an exercise of a power that is conferred, my lord, under the Constitution of India. It is nowhere else. President doesn't go outside the bounds of the Constitution. And therefore, my lord, if abrogation of 370, which would result, my lord, in the effacement of any special status that is given to the state of Jammu and Kashmir, is inbuilt into Article 370, and it is also within the knowledge of, my lord, the sovereign in the state of Jammu and Kashmir, my lord, prior to the enforcement of the Constitution, to say that I still retain some residuary sovereignty with me in spite of the enforcement of the Constitution after 26/1/1950, not reflected in Article 370, not reflected in any other provision of the Constitution of India. My lord, it's not a submission that would be countenanced by your lordships. But what are the petitioners asking for? Petitioners, my lord, say that 370, which is a temporary provision, must be treated as a permanent part of the Constitution. What form? If, my lords, is it for the purpose of, my lord, claiming for expansion of any right? Apparently not. No, my lord, because once the 370 goes, and, my lord, Jammu and Kashmir, my lord, therefore, the integration is complete even when the enforcement of the Constitution takes place. My lord, the insignia of any sovereignty is a lawmaking power. One of the insignia is a lawmaking power. That's, my lord, the lawmaking power, my lord, has been with the union and with the states, my lord, in list 2 and list 3 also. Unless, my lord, the parliament by an overarching, resort to the provisions, my lord, of lawmaking power in the list 3 also supersedes the legislation that is prevailing in the state. If, my lord, it completely therefore applies after Article 370 is abrogated, isn't there an expansion of the right, my lord, that is available to any person who says that I am a resident in the state of Jammu and Kashmir, I therefore belong to that state, I also belong to the Union of India, but therefore, my lord, what is the abridgment of the right, my lord, that the petitioners are really concerned about? No, my lords, insofar as abrogation of 370 is concerned, when the lordships would have noted that sub-article 3 was also therefore part of, my lord, in the manner in which it was framed even before 1950. I mean, on 26/1/1950, my lord, this is how it looked at. And that was at a point of time when the Constituent Assembly for the state was yet to be convened. It was convened later, my lord, in January 1951. Now, if your lordships kindly come to that for a moment. There are two places, my lord, where the Constituent Assembly for the state is referred to. Firstly, my lord, in sub-article 2, but please come to sub-article 3. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify. Proviso. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. My lord, the crucial words are recommendation of the Constituent Assembly of the state referred to in clause 2. My lord, in clause 2, the reference to the Constituent Assembly is qualified by certain words, my lord. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or the second proviso to subclause D of that clause be given before the Constituent Assembly, my lord, please permit me to read it slowly. For the purpose of framing the constitution of the state is convened. Therefore, my lord, it was understood that a Constituent Assembly will be convened for the purpose of framing the Constitution of India, as originally contemplated in Article 370 itself. But this Constituent Assembly is only for the purpose of framing the Constitution of the state. And, my lord, it is a fact which is accomplished that on framing the Constitution for the state, my lord, it dissolved itself. That it will be convened for a specific purpose and that it will dissolve itself were also matters within the knowledge of the framers of the Constitution even then. And then, my lord, therefore, in proviso, when they refer to the Constituent Assembly for the state, there was a terminus acquo, my lord, for the Constituent Assembly, which was within the knowledge, my lord, of the framers, and therefore that is what is referred to in the proviso. My lord, it could not have been contemplated that the Constituent, it was, or rather, my lord, let me put it this way. It was, my lord, it was concluded, or it was definitely, my lord, the intention that the Constituent Assembly for the state, which is convened for the purpose of framing the Constitution of the state, will have a natural death, my lord, when the Constitution for the state is framed. But when they say, my lord, that the recommendation of the Constituent Assembly for the state shall be necessary before the President issues such a notification, did they not have in mind that the recommendatory powers are therefore coterminous with the tenure of the Constituent Assembly, which has to end, my lord, with the framing of the Constitution for the state? It is not as if, my lord, the Constitution contemplates a Constituent Assembly for any purpose other than the framing of the Constitution for the state as such. Therefore, my lords, one of the termini which your lordships were referring to, there are two terminus acquo, my lord, insofar as the Constituent Assembly is concerned, going by sub-article 2 and the proviso. One is the convening of the Constituent Assembly, and the other is the dissolution of the Constituent Assembly. The proviso merely does not say Constituent Assembly of the state. It says Constituent Assembly of the state referred to in clause 2. Clause 2 says Constituent Assembly for the purpose of framing the Constitution. Therefore, the tenure of the Constituent Assembly is inbuilt, my lord, into sub-article 2 and the proviso as well. If therefore, my lord, the triggering factor, as per the proviso to Article 373, for the President to issue a public notification either abrogating it or, my lord, declaring that it will be operative only with such exceptions and modifications, is a recommendation of the Constituent Assembly of the state referred to in clause 2. It has to be inferred, in my respectful submission, that the triggering factor would be alive and operative only till such time as the Constituent Assembly is alive. And this is an inference, my lord, which I beg to infer and which I commend for your lordship's acceptance, is inbuilt into sub-article 2 and the proviso. That's why, my lord, the crucial words Constituent Assembly of the state referred to in clause 2 need not have been that way. But when sub-article 2 says before the Constituent Assembly for the purpose of framing the Constitution of India, therefore, my lord, even originally it was contemplated that this Constituent Assembly for the state will have no function other than, my lord, or will be functus officio once the Constituent Assembly of the Constitution of the state is convened. That, my lord, it's a historically recognized fact that it actually dissolved itself in 1957 itself. But that's a different matter. But the point is, my lord, for the purpose of the proviso, the triggering factor, my lord, is contemplated as being available coterminous with the life of the Constituent Assembly referred to in sub-article 2, and therefore, my lord, it ceases to have any significance, my lord, once the Constituent Assembly is dissolved and once the Constitution of the state is formed. But, my lord, it cannot, under any interpretative tool, give fodder to a submission that Article 370 as a whole, and at any rate Article 370 sub-article 3, would also cease to be operative once a proviso becomes inoperative. My lord, ideally, my lord, the proviso could have been deleted after the dissolution of the Constituent Assembly for the state. That's a different matter, my lord. One need not get into that hypothesis at all. But it cannot be contended that the power of the president vouchsafed under Article 373 would cease to be available because the proviso is no longer available to be operated upon. In my respectful submission, the proviso itself contemplates that the recommendatory power of the Constituent Assembly, my lord, whatever is the content of the recommendatory power or not, my lord, it's a different matter. I think enough submissions have been made on that. But the recommendatory power of the Constituent Assembly was intended even originally to be coterminous with the life of the Constituent Assembly, which anyway, my lord, was dissolved after the Constitution of the state was convened. My lord, my written submissions are at pages 400 to 411, my lord, of volume 3. 401 to 411 of volume 3.
411 to
401 to 411. My lord, this aspect has been dealt with, my lord. I won't therefore take up more time of your lordships on this aspect. Lord, paragraphs 1 to 4 I have dealt with this. My lord, the next submission, my lord, would be on the aspect of federalism. Lord, there are two, my lord, papers, my lord, which Your Lordships may kindly have a look at juxtaposed with each other. My Lord, one is the opening remarks of Dr. Ambedkar, my Lord, which your Lordships will find in volume 8 of the compilation of documents.
Okay,
Sorry.
If you're beginning a new point on federalism, should we take it up on Monday?
Very well.
So that